everyone, and welcome to Township Tuesday, this rainy June 3rd. I hope everyone's having a lovely summer so far. So today, I thought that I would talk a little bit about our powers to charge for emergency services. Um, so big picture here, the relevant statute is Minnesota Statute 366.011. And here's the language. A town may impose reasonable service charge for emergency services, including fire, rescue, medical, and related services provided for by the town or contracted for by the town. If the service charge remains unpaid 30 days after a notice of delinquency is sent to the recipient, the town or its contractor on behalf of the town may use any lawful means allowed to a private party for the collection of an unsecured debt. The town may also use the authority of section 366.012 to collect unpaid service charges of this kind. So let's start breaking this down. Who actually gets to impose this thing? Who is, quote, a town, unquote, in this sentence? Something the board can do on its own, something the voters need to approve, some combination of the two. Well, the association has traditionally taught that this authority is a board exclusive authority. It starts with our old friend, the catch-all provisions of 366.01. The supervisors of the town shall have charge of all town affairs not committed to other officers by law. Now, this interpretation, in my view, is strengthened pretty significantly by the contrast with nearby statutes like 366.015 or 16, which do explicitly require a vote at the annual meeting for certain powers. However, this is not a particularly well litigated statute. It's never been quoted by any court in any circumstance whatsoever. So we don't actually know. So if you want to be belt and suspenders cautious about this thing, consider asking the electors for a grant of authority under the general provisions of 365.10 subdivision 17. Nevertheless, I think this one's pretty clear that this is a board authority and not something that belongs to anybody else. However, given what we're talking about, right, there are reasons you might want to check with the electors anyway. Now, I would take the view that any such vote would be purely advisory, but given the subject matter that we're talking about and how rough this could potentially be in terms of imposing, monetary penalty on somebody who's just had obviously a pretty bad life experience, getting a sense of how much legitimacy this thing has is not the worst idea. All right. So assuming that we've got our power delegated correctly, next question is how much are we able to charge if we pass this thing? And once again, the legislature has been just about as clear as mud in this mess of a statute. But so the only guidance that we have about the limits of our power is this: we are allowed to make a charge that is, quote, reasonable, unquote. So we've traditionally taken the view that this means that the charge should accurately reflect the actual cost of providing the services. If you're considering doing this, the first step is to just develop some findings. How much does it cost to actually serve each individual, each individual property in our town? So, you count things like administrative costs, equipment costs, compensation for firefighters, including pensions and all that kind of stuff, fuel, insurance, just put it all up into one bucket and figure it out. Now, eventually these things will be used to create a fee schedule that'll be attached to the final ordinance, but first you want to understand what exactly it is that you're talking about, right? Now, we do recommend pretty strongly against simply copying a neighbor's fee schedule because I think a court's going to side-eye that one pretty hard. The cost of service vary pretty wildly between and sometimes even within the departments of the territory of different fire departments. So this is the kind of thing to be careful with. Okay, so the town board gets to do this and they get to impose a charge that is, quote unquote, reasonable. So what exactly what services can we charge for? Now, two of them are quite clear. Right, fire, rescue, fire and rescue are sort of traditionally grouped together. They don't necessarily have to be, but all the departments that I've encountered, it's the fire department that does the rescuing for the most part. And then emergency medical services. It is not super clear whether the authority extends to police. You might want to be cautious and take the view that it doesn't. Other statutes in this area tend to mention the police explicitly when they mean to include them. For example, 365.15 says fire and police, 365.16 says fire apparatus and police apparatus, but this is by no means certain. You definitely could argue that emergency services, by its nature, includes police, right? And that's probably the first service that came to your mind when I started talking about emergency services. I know for me personally, when people start talking about emergency services, that's usually who I think of first. And particularly given the way that our statute kind of, if we flip back here, talks about this as a sort of as an inclusive way, including fire, rescue, medical, and related services. So you could take the view that, like police are related to rescue. Sometimes they're the ones who do rescue, and that the choice of the word including means that they meant that list not to be exclusive. So police count. But, just so there is that little ambiguity there. Okay. So how do we practically go about doing this thing? So we do recommend an ordinance and have for a while here. And part of that ordinance should, we should identify the services that we're specifically charging for. We should outline the process explicitly here. So, fire department has to ensure that it's recording names and addresses of the person receiving the services. There has to be, penalties in the contract. That information will need to be forwarded to the town in a timely manner, and that should be included as a requirement in the fire contract itself as a condition to the payment of the service charge. Somebody should be designated to carry out the billing process. Doesn't necessarily have to be the clerk, doesn't necessarily have to be the treasurer. Certainly those are not on their list of statutory duties, but of course they can agree to do that if they like. And then whoever ends up doing that has to be, of a mind that they are going to be keeping detailed records of what service was provided, when, how do we know. We should have a detailed record of the correspondence with the person who received the service and their responses. We also need to have a process in place for what happens if the landowner doesn't agree, right? If they dispute the charge, if they dispute the amount of the charge. And then we want to be very careful to have a plan in place for what happens if they don't pay, right? Now, of course, if we're doing this, we cannot forget the ordinary ordinance formalities here. These are pretty straightforward. It's Minnesota Statute 365.125, but you need that classic majority vote. You need a signature by the chair. You need attestation by the clerk. It needs to be the proper style, so it needs to start the Board of Supervisors of the town of X ordains, and then you need to publish it and you need to record it. So we've got guidance up on that on the website. Happy to walk through that process with folks who are interested. But I think this is probably the big decision related to this thing. If you do it, are you going to be certifying this to the landowner's taxes? So, of course, you have to decide in general how you're going to handle unpaid service charges, if you're going to use sort of general debt collection kind of practices, if you're going to be inclined to let it go. But so if a charge remains unpaid 30 days after a notice of delinquency, we are entitled to use any lawful means allowed to a private party. But of course, we are also allowed to use 366.012, which is the certification of these service charges. So on or before September 15th of each year, we notify the landowner in writing that we intend to certify this. If they still haven't paid it, then on or before October 15th, we certify that to the county auditor. And then that goes together with their ordinary property taxes to be collected and then remitted to us. This is a bit of a sledgehammer, of course, but it is potentially an option. And particularly when you're designing your ordinance, you should think through whether or not this is something that you're really going to want to be doing. But okay, so in order to practically administer this stuff, there's things that you're going to need to have in your hand before you make this thing effective, right? You're going to need a free fee schedule. You're going to need sample notices with invoices. You're going to need sample notices that give kind of notice of the process that you're going to be using, and then forms for the person who's going to be administering this thing. So, fill in the blanks for, all right, here's your hearing date, here's how you contest, and then you're going to need a plan for enforcement. So is this going to be something that you are handing off to the city? We are empowering you, city, as our contractor to do this so that you guys get to be the bad guys. This is going to be something that we do ourselves. Are we going to use this certification process, or are we not? All that stuff needs to be worked out. Now, in terms of other practical considerations, looping the service that you're going to be trying to use in here is going to be pretty important, because of course you need a detailed factual basis in order to survive that reasonableness test, or at least that we expect that. So we want some in-depth factual findings about why it is that you think you need to charge this much in order to support your fire service. And then you're going to want to get input, particularly if this is something you decide to enforce yourself, from the attorney who's going to be doing the enforcement work, because of course they have to have confidence in the process if they're going to be the one who's doing this in the first instance. Now, here's a consideration that I think is potentially worth bringing up here. You might not want to draw attention to this power, because assuming that you're receiving services from a nearby city, passing one of these, particularly the publication, particularly the contracting process, can alert them to the fact that this set of powers exists. Now, cities do have this power, sort of, but it's in a bit of an out-of-the-way statute. My impression from perusing the League of Minnesota Cities sort of content around this is that a lot of cities aren't aware that they can do this. They sort of piggyback onto our powers. And so if you don't want, if you're dealing with somebody, a next door neighbor who engages in sharp practice around this stuff, this is potentially a reason to be cautious, aside from, of course, just the potential inequities involved in, paying for a service on the back of somebody who's just had a fire or just had a medical emergency, or all that kind of stuff. And of course, at the end of the day, this is just one power to consider out of many to sort of deal with our funding issues related to emergency medical services. So just so you are aware, here are some of the other lesser known powers that talking to folks throughout the state, I feel like folks are not super aware of. We've got some special powers related to extinguishing fires on trunk highways. We're entitled to reimbursement from the state under certain circumstances. There's a really expansive reimbursement from railroads. If you can trace the fire or the emergency to a railroad in some way, you can often get reimbursed for that. So it's worth potentially considering passing some policies related to that. And then of course there are special fire protection districts. So towns can do this in a couple of ways. 368.85. You can create a special district with certain taxing powers, and then 144F.01. That's one that's not particularly well known. That one allows both EMS and then also fire as well. Now the requirements for those two things are different. And at the end of the day, we are dealing with a situation where costs are just increasing pretty wildly, and our tax base is just not. So this is not necessarily, none of these things are silver bullets here, but each of these are tools potentially in the toolkit that you could consider using. So, all right. I see that we hit, I was seeing a couple of chats there, so let me go ahead and click on this open. Is information the same if EMS is run by a joint powers board? Yeah, you could. I would take the view through the contracting provision in that statute. You could allow them to use this power if they like. A joint powers board is sort of it's a weird little beast. every government power in the state of Minnesota, or I should say every local government power in the state of Minnesota, can be exercised by sort of a cooperative. Now, we see this a lot in zoning, for example. A lot of small townships just don't have the resources to do zoning properly. And so what they'll do is they'll kind of club up, they'll create a joint powers entity, and that joint powers entity has their zoning powers. And so they'll hire the administrator, and that person is the one who will field the requests and, make recommendations to the particular board and that kind of stuff. But it's not limited to zoning. It can be done for kind of anything. Any government power can be exercised in that way. And so, when a group of cities or townships sort of get together, they can be served by EMS. They can do it that way. So, yes, we joint powers entities can do that. All right, folks. Any other questions here? Okay. I will say, if there's appetite for a deeper dive into this, we do have some guidance documents up on the website. If there's appetite for a deeper dive on this, we certainly could start developing, some sample notices, some stuff to use to make this power items designed to sort of make using this power a little bit easier on folks. I don't know how often this thing is used in practice. But just given the sort of the funding challenges that we've been hearing about, I just wanted to make folks aware. Okay, I'll pitch that to the legal department and let's see what we can do here. No promises about getting this one out the door quickly, but I mean, like, this is an issue that we've been seeing a lot of concern from our membership on. So I'm just trying to be on the lookout for tools that folks can use potentially to find funding in the absence of action from the state legislature on this kind of thing. Okay. Well, in any event, I hope that was helpful. Please do reach out if you've got any other questions, comments, concerns, if you've got any other ideas for Township Tuesday topics that you'd like to see. Otherwise, thanks for your time and attention, and have a nice morning, everyone.